Today I'm going to talk to you about compensating trauma, medicine, rape and redress in 1980s Australia. My name's Lisa Featherstone and I'm an Associate Professor at the University of Queensland in Australia. I'd like to acknowledge that I live and work on the lands of the Yagara and Turrbal people who have looked after this land for thousands of years. I feel every day that I'm lucky to live on their lands here, and I acknowledge the leadership and ownership of this land by the elders past, present and future. I'd also like just to draw your attention to a content warning. This talk and the PowerPoint contain information about sexual violence, including rape and child sexual assault. And a lot of it is quite sensitive material. There are quotes from survivors, and there are also verdicts from judges that I think would be upsetting to some listeners. So I draw your attention to that. Since the 1970s, there's been a wealth of feminist, historical, legal, criminological and sociological scholarship on sexual offending, highlighting the ways that the criminal justice system has failed victims who have been sexually assaulted. We know that sexual crimes are and were dramatically underreported, and that those cases that did go forth to prosecution, we know that few were found guilty of sexual crimes. Complainants faced a raft of difficulties, including rape myths that were utilised by defence lawyers and believed by jurors. There were evidentiary exclusions which made it difficult to prove sexual violence. And there has been a tendency for the court to put the victim on trial rather than the offender. So the difficulties facing a victim survivor within the criminal justice system have been manifest. So today I want to talk about a rather intriguing shift in thinking about legal responses to sexual crimes, and to frame it as a glimmer of resistance to the traditional judicial model. I'm going to focus on a small but rather profound change that occurred across the 1970s and 1980s in Australia. The use of the compensation claim as just one more way to respond to sexual violence within the courts. Though civil compensation is now entrenched in the legal systems in Australian jurisdictions, and this sits alongside government schemes of redress, I think it's worth revisiting these origins to consider the role of trauma in the development of compensation claims, and to think through the ways that a victim's experiences were reframed by and in the compensation claim. In 1967, in New South Wales, which is Australia's largest jurisdiction, new laws were introduced that allowed crime victims to seek compensation from an attacker. This was part of a broader attempt to support survivors and acknowledge their often considerable injuries. While the laws were most often used for violent street crime, under the legislation both adults and child complainants could seek compensation for sexual assault. I will argue that compensation claims were one way that survivors of sexual violence sought a form of justice beyond the criminal trial. My sample of cases from the 1970s and 80s suggests that once the decision was made to seek compensation, cases were likely to be successful. Sometimes monetary compensation was granted even in cases where the defendant had been found not guilty in a criminal trial. Then, as now, the rules of evidence were different for those used in a criminal trial. So there's a difference in evidence in a criminal trial and a compensation claim. The hearing for compensation generally occurred directly after a trial or sentencing hearing and was heard before the same judge, who would thus be familiar with the intimate details of the case. In these instances, the judge would be provided with, or could call for, additional information that had not been admissible at trial. The burden of proof was thus lower than in the criminal court, and judges were certainly not afraid to grant monetary compensation even if the accused had been found not guilty. None of this is, of course, to suggest that this was not a debilitating and in some ways rather ludicrous process for the complainant. She had generally just been through a long and arduous trial, and now she had to front the court again. It is both ironic and alarming that the very same judge might grant her compensation, having presided over a jury that had found the accused not guilty. It is frankly in some ways, I think, a rather offensive proposition. Yet at the same time, I wish to acknowledge and discuss this slither of subversion of the criminal justice system, this ever so slight undermining of the criminal trial that so disadvantaged the complainant. So from the very start, I want to acknowledge the victim survivor and wish to interrogate this process and why complainants still saw seeking compensation as a useful exercise. The cases that I'm going to consider in this talk today are drawn from a database of sexual offences developed by Andy Kalajalfis and myself over many years. Created, it comes from research in the Supreme Court and Quarter Sessions records of New South Wales, which is Australia's largest jurisdiction. We've examined 610 full and partial court transcripts from the years 1970, 1975, 1980 and 1985. And these include trials, sentencing, hearings, and compensation claims. These transcripts do not represent all court cases for compensation that would have been seen in these years. Rather, they represent court cases that the court saw fit to record, probably because they thought that there may have been a challenge against them, an appeal perhaps. This means they provide an imprecise measure of what's going on in court, though I think as time goes on, more and more are recorded. But they are still an imprecise measure, and we need to be careful about drawing statistical information about what happened from them, though we can, I think, draw on some broad themes, and certainly they provide important information for qualitative analysis. The court transcripts are imperfect sources because they're sometimes fragmentary or incomplete, and sometimes not all of the information is recorded. Nonetheless, they do provide rich discussions about crime and compensation and what this meant for both offenders and for victims. In the sample of New South Wales compensation cases, the claimants for compensation were overwhelmingly adult women. This gender imbalance perhaps reflects the realities of the compensation process, which I think required a courtroom attestation of physical and mental harm. Male victims may not have been willing or able to endure this kind of public casting of themselves as a victim, given the social norms about masculinity and physical prowess and virility. Economic features may have also shaped this gender distribution of complainants. Women's lower pay rates in this time period and reduced career opportunities may have created a financial strain that forced women to court to look for compensation. The compensation claim has some of the same functions as a trial. As with all courtroom interactions, the court and judiciary retained strict protocols concerning evidence from the complainant. And I guess the performance of the hearing remained quite formal and unemotional. Issues of economic value, such as hospital costs and lost wages, were really core here. But the process did allow for some testimony, however fragmented, of a victim's experience. And this is in his or her own voice. This is one of the few forms of courtroom interaction where the complainant's trauma, the harm suffered both at the time of the assault and afterwards, is discussed at any length. Because normally in court trials, in a trial, discussion of harm is very much minimalised. It's not central to the court's agenda. The court is trying to ascertain whether or not an assault has occurred, whether sex was with consent, and whether the offender was in fact the person who had committed an offence. The trial then focuses on the mechanics of a social and sexual encounter, the resistance to sexual contact, and what violence might have occurred. They also look to how consent was shown. In cases involving children, there are other issues, including proof of age and sometimes relationship between the child and the accused. Within the trial, none of this involves discussions of harm to the actual complainant. But here in the compensation claim, suffering was illuminated. The complainant would be expected to delineate not just what happened, but the harm, both at the time of the offence and the ongoing economic costs, the social repercussions, and the individual anguish of sexual violence. In addition to testimony from the survivor, medical evidence was provided to add weight to the spoken word of the survivor herself. This in itself is quite intriguing, as in Australian courts, medical evidence was quite often in this time period either undermined or ignored. I think this is largely because sexual violence in many cases didn't leave a great deal of evidence on the body. It doesn't leave signs on the body, especially if the victim is a child. And psychiatric evidence was often only seen as a tool of the defendant when he or she are hoping to ease a sentence. So there was almost something of a shadow of a doubt over psychiatric testimony in this time period. But in the compensation claim, medical evidence appears to have been utilised to more effect for the victim rather than for the accused. The claimant used testimony from a psychiatrist or psychologist to assert a claim to trauma on medical grounds. It also provided an opportunity to reiterate, really to repeat, the various forms of harm that were done to the complainant, this time in the authoritative language of medico-legal terminology. So let us consider some cases, and in particular how attitudes towards trauma and compensation change over time, evolving in meaning across the 1970s and 1980s. Based on the available court transcripts, claims for compensation for sexual violence were initially fairly uncommon. In this sample, claims from the early 1970s, which is not very long after the legislation had been introduced, tended to focus on the recovery of medical costs and other direct impacts. Even when the claim revealed extensive psychological trauma, compensation was only peripherally about this harm. Instead, compensation was aimed at tangible, pragmatic outcomes. In 1970, for example, a young male offender was brought to court for a sentence hearing and a compensation claim. He had pleaded guilty to the rape of an adult woman, having broken into her home, threatened her with a knife, and raped her. He had pleaded not guilty to the second offence, which was ongoing. Collins J. explained that the offence was, I quote, very serious, but noted that it went in the accused's favour, that he had pleaded guilty and that he was aged only 19. The offender was sentenced to 8 years with no chance of parole for 4 years. In the compensation hearing, the victim, a young woman, was called to the stand. Her defence lawyer asked her a series of questions to establish that she had sought medical assistance from a doctor, 2 pathologists and a psychiatrist. She was then asked to explain her injuries. The young woman told the judge that she had caught a sexually transmitted disease which had appeared after the sexual assault and which required medical treatment and pathology. Her lawyer then asked about her nervous condition. She had visited a psychiatrist for her deteriorating mental health. But after she had received no report, she'd received no report from this psychiatrist because he demanded full payment of the $40 consultation fee before he would consider writing a report. And the report itself would cost an extra $20. In a period before any kind of medical insurance, Medicaid or Medicare, there was no government assistance for the complainant, and so she could not afford to get a medical report. When the judge questioned her on the opinion of the psychiatrist, she explained, he said that I was in a shocking state, that I just had to try and forget it, and I just cannot. But there was no detailed examination of her mental trauma or psychological outcome. The complainant herself was not questioned in any detail, and it was not seen as important to follow up with the funding for a psychiatric report. The judge acknowledged her injury and loss, using those words, injury and loss, stating that she had suffered bodily harm from a sexually transmitted disease and, I quote, clearly suffered mental and nervous shock. He directed payment of $600, of which $80 was for medical bills and the rest for injury suffered from the assault. That was a relatively small settlement, given the maximum allowed under the Act in 1970 was $2,000. The investigation into her trauma was relatively minimal, and while harm was acknowledged, it was not fully investigated in either medicine or in the law. By the mid-1970s, we begin to slowly trace shifts, I think, slow shifts, in the meanings of compensation and trauma. but the emphasis remained on certain kinds of damages, in particular on physical trauma and on reimbursement for the direct costs of the assault. Psychological harm was mentioned but not prioritised, and I'll give you a couple of examples of this. In 1975, a young married teacher was raped by 2 offenders, and they were imprisoned for the crime, so they're found guilty, and she sought compensation. Justice Nagel offered the following information on the compensation claim. After the sexual assault, the woman was hospitalised at Griffith Base Hospital for several days. But Nagel J explained that although it must have been a most distressing happening to occur to her, her physical injuries were not great, he said. She had consulted a psychiatrist and the psychiatrist reported, and I quote, that she had suffered psychiatric injury, which, I quote, will persist for some time, and it will be quite a while before she returns to her previous personality. The young woman was also off work for some months following the assault. She was granted compensation of $3,839, half to be paid by each of the 2 offenders. But of this, a significant chunk was for direct medical costs and the loss of income. So $839 of the $3,839 were for those direct costs. The final sum for her physical and emotional trauma was relatively low, and this seems to have been because her physical injuries were relatively minor. And we can see how her considerable psychological trauma, which required significant time off work and resulted in a change in her actual personality, we can see how this was minimised within the compensation claim. A second case from 1975 illustrates the propensity to value both direct medical costs and physical injury over psychological harm and trauma. A few years later, a judge might even recommend a victim should seek compensation for damages. Yet this remains largely framed within a context of extant losses. For example, in 1975, a man pleaded guilty to 5 sexual offences against children aged between 6 and 10 years and to 1 count of indecent assault against an adult woman. So he's got a number of charges against him here. During the proceedings, a 7th charge for common assault against a child was added, so it's 7 charges all up. All had experienced various forms of sexual and physical violence, and in some cases the offender had actually threatened to kill the child if he or she had screamed out. One of the children in particular had suffered psychological problems afterwards, which was noted carefully by the judge in the sentencing remarks. The adult woman had been indecently assaulted but had fought back and was able to grab the offender's knife and also scream for help. The offender had hit her in the face, breaking her dentures, cutting her face and bruising her cheek. At the final comment in the sentencing, the judge suggested that the adult woman should be contacted, the woman was not in the court at the time, suggested that the adult woman be contacted and encouraged to seek compensation because of her straitened financial circumstances, he says. Damages could be sought, the judge noted, for her injuries, and I quote, she suffered a swollen, cut and bruised face. She was subjected to an experience which must have frightened her very much indeed, and her dentures were broken, quote, unquote. No similar suggestion was made for any of the children, who had also suffered frightening and potentially traumatic assaults. In her suffering, the adult woman had suffered from financial loss, mental trauma and physical assault, also the loss of her dentures. This was all due compensation in a way that the children's psychological harm was apparently not. So that's in 1975. But by the new decade, I think discussion in the court over compensation would allow for a more thorough dialogue over the victim's trauma. This was due, at least in part, to changing medical and psychiatric attitudes towards sexual violence. Medical journals had begun to publish on rape trauma from the early 1970s, and by the end of the decade there was a small number of significant articles that detailed the long-term effects of sexual abuse on children in particular. Probably more influential was the broader scientific understandings of trauma and harm, including the introduction of a concept of PTSD in the American Psychiatric Association's Diagnostics and Statistical Manual of Mental Disorders, known as the DSM-3, in 1980. The DSM-3, which was the most influential psychiatric text of the time, acknowledged rape might be a psychologically traumatic event. At the same time, second wave feminists had highlighted the impact of sexual violence on women and girls. And they'd spoken, feminist ideas had spoken about the trauma suffered at the moment of assault, but also that this impact was ongoing and long-lasting, well beyond the initial assault. So feminist ideas about rape, about incest and child sexual abuse infiltrated the mainstream media in the early 1980s across Australia. And by this time period, it was increasingly difficult to ignore sexual violence as a social, medical and psychological problem for individuals and also for the wider community. Yet, as I've shown elsewhere, concepts of trauma would take considerable time to filter through to the court systems. So what's happening in medicine and indeed in wider society does not always transform courtroom practices. Within the courtroom, we first begin to see change, I think, within these compensation claims rather than within the trial itself. So, for example, in 1980, a man pleaded guilty to the rape of a young woman in her own home. She had been asleep with her boyfriend when the offender entered the home with another man. They had tied up her boyfriend and she was raped by the offender while the second offender looked on and masturbated. In the hearings for compensation, the complainant told the court that she had suffered multiple impacts of the assault. She said of the time that she, and I quote, "I was totally terrified by the whole thing and my nerves were shot to such a stage that I thought that possibly I would die from nervous exhaustion if I was not killed by either of the offenders." And she also explained that she had suffered a series of problems after the assault. She said she had to actually sell her house because she was no longer happy living there. She didn't feel safe. She said, "I was just terrified. I could not go about my normal household duties. It was affecting everything. The total fear of being in your own home and being frightened, it affects everything." She also said that moving house didn't actually fix the problem. She was afraid of another attack and she really did just fear that wherever she was unsafe. Her explanation of the trauma resembled what had recently been defined as post-traumatic stress in the DSM. Her fear and anxiety were triggered by certain events and memories, including seeing a man who resembled the offender, reading about an assault, or seeing something violent on television. She had bought a large dog for protection, but then she said that she was frightened every time the dog barked. So while before the assault, she said she'd been social and broad-minded. After the assault, she avoided parties and anywhere where couples might be intimate, and indeed that her own sex life had really suffered considerably, she said. And a raft of evidence is presented to show this. Her GP is called, and this is seconded by a specialist psychiatrist. She had been diagnosed with acute traumatic neurosis, and this is what the psychiatrist explained was a condition, I quote, whereby people who are subjected to an extremely frightening experience, it is very common in wartime, experience where people fear for their life, develop an anxiety as a result of the experience they went through, and anxiety, sleeplessness, things like that. Her trauma was no doubt magnified by the fact that the prisoner was allowed to represent himself and was thus able to question her during the courtroom proceedings, both about the sexual acts on the night of the offence, and he also asked her questions about how she felt being interviewed by him in the courtroom. In the judgment for compensation, Justice Lee opened with an acknowledgement of the woman's very considerable emotional upset. Lee Jade detailed a psychiatric report and went through the fact that she had suffered fear, tension and headaches. There was a number of other costs noted, including legal fees, $1,500 worth of that, and tax on the sale of the property, which was just over $1,000. The woman had sought help from a social worker, and she had gained some relief from this, but the justice said, "I see no reason to disbelieve that she still has fear. She is constantly reminded of it in all sorts of ways. She feels that it could happen again, and I think no more need to be said that it is not hard to believe that this experience will take a long, long time before it departs from her memory completely, if it ever does." So Justice Lee awarded the maximum of $10,000 compensation, and he justified this because of her emotional upset, is the term he uses. By the 1980s, there were many similar cases, with the judges framing compensation around emotional harm. In cases of intrafamilial sexual violence, more often judges and justices acknowledged the suffering and trauma of intrafamilial abuse. With the lesser evidentiary requirements of a compensation claim, trauma could be acknowledged and interpreted to gain an outcome favourable for the victim survivor, at least financially. In some instances, women were not only granted the full amount of compensation, but the justice acknowledged that he would grant more if he was able. So I would suggest by the mid-1980s, such testimony followed a fairly well-worn path, and it begins in some ways to resemble what would later become formal written victim impact statements, which were generally presented after a conviction and before sentencing. So this predates the introduction of victim impact statements, but I think there's similarities in some ways to how these operate. So, for example, in 1985 in Newcastle, which is a large industrial city north of Sydney, the District Court heard an application under S4 for compensation, where where a young woman sought compensation for injuries obtained during a sexual assault. The offender had been charged, the accused had been charged and acquitted of one count of malicious bodily harm with intent to have sexual intercourse, and charged and acquitted of one count of sexual intercourse without consent. The alleged assaults had taken place when the young woman hitched a lift with the accused, and she claimed that once they were in an isolated location, he had forced her into a sexual act without her consent. At a hearing for compensation, Justice Ducker noted that his court was privy to material that had not been available to the jury at the time of the trial. And this included reports from a general practitioner who had treated the victim before the alleged assault, also a report from a counsellor from the from the sexual assault centre at a hospital, and separately from a psychiatrist. The reports built on the justice's observations from the trial that the young woman was considerably overwrought by these events, and they were far from resolved in her mind. During the criminal trial, the judge had noted that the complainant had exhibited a considerable degree of hostility towards the accused, which of course I guess is a natural thing. But the judge also felt that her assertiveness on the stand was at odds with the passivity of her reactions to the sexual assault. Of course, she explained this, that she was really terrified for her life and thought that if she reacted too strongly, that the accused might actually have killed her. But the judge suggested that this had gone against her this kind of disconnect between her assertiveness in the courtroom and her lack of assertiveness during the sexual assault. And so the justice speculated that this was the cause of the not guilty outcome, though he claimed he had no doubt that a criminal act had occurred. The complainant's testimony was well supported by the medical evidence, which of course hadn't been available at the criminal trial, including the lengthy and detailed psychiatric report. Justice Ducker awarded her the full amount of possible compensation of $20,000, despite the fact that the accused had been found not guilty in the criminal courts. So, today I've looked at ways that concepts of trauma and harm were illuminated in compensation cases in 1970s and 1980s Australia. And I've shown that two broad themes have emerged. First, we've seen that across this period, ideas of trauma were slowly illuminated in the courtroom. This is slow and it's hesitant. But it is different. More broadly, in trials and sentencing hearings, trauma to the victim was rarely acknowledged in any kind of meaningful way. The trial itself was absorbed with the accused, and the survivor's psychological state was peripheral to the main agenda. And this is where the compensation claim provides a moment of clarity around concepts of trauma within the courtroom. If in the 1970s compensation was largely directed along pragmatic lines, so physical damage, medical costs, by the 1980s compensation was beginning to provide one route to acknowledging the psychological trauma and harm of a complainant. This is a distinct shift, a turning point by the mid-1980s. So we start to see trauma taken seriously, perhaps for the first time in the Australian courts. And this occurred even in cases where a guilty verdict had not been found. So the use of compensation claims to mitigate trauma presents us with a profoundly difficult conceptual consideration. On one hand, the use of compensation processes hints towards a clear failure of the judicial system. At the compensation hearing, the judge would suggest that additional information led to the conclusion that the accused was in fact guilty. This information, for example, psychiatric reports, was not allowed into the criminal trial. And so here we have a very uneasy alliance between the rights of the accused and the rights of the complainant. So, on the other hand, compensation at least allowed for some discursive and monetary acknowledgement of a crime. In the absence of a guilty verdict, it was a tacit acknowledgement that a crime had taken place and that the suffering that a victim had experienced was in fact real. It was, I would argue, a very poor cousin to a proper verdict. But the willingness of complainants to stand in court once again, after all of the horrors of a criminal trial, shows that compensation did actually mean something. It means something important to the victim's survivor. The compensation claim represents both a failure of the system for victims, but paradoxically, it means something significant in both economic and cultural terms, and that is acknowledgement of the suffering and harm that they had endured. Thank you.